What is the International Criminal Court? Why was the court established?
The International Criminal Court is the first international and permanent criminal court established in order to put an end to the impunity of the perpetrators of the most serious crimes, namely genocide, war crimes, and crimes against humanity. These crimes are of concern to the international community as a whole. It has been established by an international treaty, the Rome Statute, adopted during a conference in Rome in 1998. Currently, there are 121 states that are parties to this Rome Statute, and the largest group of states that are parties is currently the African group, where we have 33 African states that are parties to this statute.
Is the ICC an office or agency of the United Nations?
No, the International Criminal Court is a completely independent institution, and contrary to a lot of other institutions, it has not been created by a resolution of the Security Council or a decision by the United Nations. It has been established by an international treaty, the Rome Statute. As two independent entities, the International Criminal Court and the United Nations have concluded an agreement in order to organize their institutional relations.
What measures has the Office of the Prosecutor taken since the referral from the government of Mali in July 2012?
Since the referral, the OTP had been conducting a preliminary examination of the situation in Mali. After careful analysis under Article 53 of the Rome Statute, including an assessment of admissibility of potential cases, the OTP has determined that there is a reasonable basis to proceed with an investigation. We will publish a report today. After this report will explain in detail how we came to this conclusion.
What crimes will the Office of the Prosecutor investigate, and how will the investigations be conducted?
First of all, let me stress that as we did in other cases and we continue to do, the investigation will be independent and impartial. There is the law and we are applying Rome Statute. It is a judicial mandate. Secondly, what I want to stress and underline is our policy is to focus on the most serious crime committed in Mali since January 2012. And also, we are investigating those who bear the greatest responsibility for this crime according to the evidence we will collect, independently and impartially. You know, the office has analyzed information since the referral in January 2012 about acts of murder, attacks against protected objects, mutilations, cruel treatment and torture, passing and execution of sentence without due process, rape and pillaging. This was the result of our analysis of the communication we received. Now that we decide to open an investigation, let me underline strongly that as we did in the past and we continue to do, this phase of investigation, the office will interact with witnesses to take statement and evidence, including, as you know, documentary evidence from individual, any person able to clarify what happened, and from relevant places like crime scene and other relevant sources. We expect, after doing all this, that we will be able to determine the higher level responsibility. And as I already underlined, we are investigating the most gravest crime committed by the higher level responsibility. And on that, we think and we have any doubt that the Malian authority will continue to cooperate with us because we are interacting with them in a daily basis. We count on them to have this cooperation, but we count on the international community also to support the investigation of this alleged crime in Mali, to move swift and efficiently in bringing justice to the victim in Mali.
Who can be prosecuted by the ICC for the crimes in Mali?
As I told already, we will investigate and prosecute individuals who, according to the evidence, because I remind you that we will ourselves collect our own evidence. We are not counting on anybody to collect them. The support will be the communication we receive from diverse sources. And after this analysis, in which we have determined our jurisdiction and the receivability, admissibility of the case, we will go through the papers to the terrain, to the ground, to collect ourselves our evidence. Will be evidence collected by OTP staff under the instruction of the prosecutor and the executive committee. According to this collection, what we will do is to analyze this evidence and to go through the more greatest responsibility. And don't forget our strategy. And this strategy is aligned with Rome Statute, is to prosecute and investigate and prosecute the person having a greatest responsibility, criminal responsibility for the most serious crime committed in Mali. It means who? The person who plan, who organize, who finance, and have really a great responsibility in terms of giving order, financing, organizing, and planning. As you can see and know, ICC can investigate or prosecute crime committed since July 2002, when the Rome Statute came into effect. Mali is a state party. Authorities of Mali referred the case to OTP on January 2012. Who these individuals are will depend on the evidence, and the evidence will be collected during this investigation phase.
Who has to execute the warrants of arrest?
The responsibility to arrest the persons that are suspected of the most serious crimes, war crimes, genocide, and crimes against humanity, is a responsibility for the states. When they created the Rome Statute, the treaty founding the ICC, the representative of the states created a system with two pillars, a judicial pillar and an operational pillar. The judicial pillar is the court, the International Criminal Court, which has to open investigations, gather the evidence, and eventually deliver arrest warrants. And the operational pillar, these are the state who have to cooperate with the International Criminal Court, including for the purpose of the arrest of the persons who are suspected of these very serious crimes. The ICC does not conduct trials in absentia. That means that we need to arrest the suspects, or we need the suspects to be present before the judges in order to continue with the proceedings. However, the crimes that are prosecuted by the ICC, the war crimes, crimes against humanity, and genocide, these are the most serious and the most grave crimes. They shall not be subject to any statute of limitation. That means that the warrant of arrests are valid lifetime, and the suspects will be present before the ICC judges sooner or later.
There are allegations that the ICC is only targeting African countries. Is that true?
The International Criminal Court is a judicial institution that is permanent and independent. It is not subject to any political control. The decision of the judges cannot take into consideration any political motivation. The decisions of justice can be delivered only on the basis of the evidence and the rules that govern the work of the justice. The ICC is concerned with war crimes, crimes against humanity, and genocide when committed on the territories of states that voluntarily accepted the jurisdiction of the court, or by citizens of such a state. And these states are across the world. There are 121 states that are parties to the Rome Statute. Currently, the ICC has opened 8 investigations related to African countries. But in 4 of these 8 investigations, it were the countries themselves that asked the ICC to open the investigation, as Mali have done recently. The Democratic Republic of Congo and Uganda and Central African Republic have submitted to the ICC prosecutor a request in order to open an investigation for the crimes that have happened on their territories. In 2 other situations, Libya and Darfur in Sudan, it was the Security Council that asked the ICC to open an investigation by a resolution under Chapter 7. The ICC is also conducting preliminary examinations that might lead to the opening of investigations, and these preliminary examinations are conducted for countries on 4 different continents, including Honduras, Colombia, Afghanistan, Korea, and other countries. The ICC would not have been created without the African support. During the Rome Conference in 1998, it was the African representative that made the strongest and the most meaningful declarations, and they influenced the decision to have a fully independent Office of the Prosecutor. There was also 43 states from Africa that voted for the adoption of the Rome Statute. Without this support, the Rome Statute would not have been adopted. The trust and the support does not come only from the African states, but also it comes from the civil societies in the states. And this civil society continues to support the ICC until today.